Today's conversation with music attorney Cassandra Spangler is about trademarks in the music industry. The information provided in this video is for informational purposes only and not for the purpose of providing legal advice. You should contact an attorney to obtain advice with respect to any particular issue or problem. Okay, so we're here once again with Cassandra Spangler, music attorney extraordinaire from New York. And today we're going to talk about trademarks because in our last conversation, that kept coming up. So we thought, well, maybe that's a good topic to talk about next. So before we talked about LLCs, and now we're going to talk about trademarks. So welcome, Cassandra. It's always nice to have you here.
Thanks, Janae. Always a pleasure.
And today we're, like I said, talking about trademarks. And as usual, because you are the expert, I'm going to sort of let you rock with this and just, get it started with the very simple question, which is what is the purpose of a trademark? Or maybe even back it up. What is a trademark?
Sure. Yeah. And just a side note, I think it's a very timely topic because the Trademark Office, which I'll talk more about in a minute, they have actually received a record number of trademark applications over the past year. So while everybody's been at home, with the stay-at-home orders, they've been getting all of their various types of paperwork in order, and trademarks have been a huge area that people have been working on. So I think it's important really for everyone to kind of understand what a trademark is, why you should register your trademarks, etc. So it's a hot topic right now.
Well, that's great to hear. It almost sounds a bit like, the whole copyright thing when people finally caught on to that. Now the wait is like really long.
Yes. Yes. The Copyright Office, I think, has realized that people are all now kind of aware that they need to register their copyrights. So lately their wait times have been pretty good. They're back to about 3 months, but you're absolutely correct. For a while there, it was, some of the copyright applications I was submitting for clients were taking a year, which is crazy. And that's kind of where the Trademark Office is at now. They're taking months and months and months to even look at the application. So anyone out there who is considering registering your trademark, sooner is better than later, because especially because of these long wait times.
So what is a trademark? What's the big deal?
Sure, yes. So to review, I think in a prior talk, Janae and I kind of went over the differences between the various types of intellectual property. Trademarks are a form of what they call intellectual property, which means that it is something you own that is sort of intangible. So the big three, just as a quick review, are copyrights, patents, and trademarks. There's some others, but those are the main forms of intellectual property. Copyrights protect artistic works, patents in general protect ideas and inventions, and then trademarks, which we're focusing on today, those really protect your brand. So those trademark protects your brand name, your logo, in some situations your packaging, and sometimes a catchphrase, those types of things. Anything that's used to identify your products or services as coming from you would be considered a trademark.
And I already answered this in my head, I think, but I kept thinking while you were talking, well, so does it ever expire the way patents do?
Yes. So one of the main differences between trademarks as opposed to copyrights or patents is that trademark protection continues only as long as you're using it. So with a copyright, for example, the copyright lasts for a set number of years. It can be renewed, but it's still a set number of years that the protection lasts. With trademarks, it lasts for as long as you're using it. So if you stop using the name to function as a brand name, you'll lose the trademark protection. And the flip side of that is if you continue using it in the proper way and you keep, renewing the registration, then you can theoretically, the protection will last, for a very, very long time.
Okay.
So how do you register a trademark? So a trademark, again, it's different from a copyright. This is a very common question that I get from clients who are artists, and they get kind of confused about, do they need a copyright or do they need a trademark? And again, copyrights protect your artistic work. So your recordings, the songs that you're writing, your lyrics, those are all in the copyright category. Trademarks protect, in the context of music, they would protect your stage name. If you have your own record label, they protect the name of your label. If you have a logo, they protect the logo. So when it comes to your name, which is most commonly where we would see it in the music industry, that would be a trademark and not a copyright. So a lot of times I have people call in, they say they want to copyright their name. Technically, what you want there is not a copyright, but a trademark. Trademarks are also a little different from copyrights, where copyright law, the intention is to encourage people to create. So, in order to encourage people to create, they have this protection, which is the copyright. Trademarks are not really intended to encourage creation, they're intended actually to protect consumers. The purpose behind providing legal protection for trademarks is so that when a consumer purchases a product or a service under a certain name, they kind of know what they're going to get. So, in the early days, a lot of this centered around food products and things like that. So if you're going into the store and you're purchasing a can that says Coca-Cola on it, you sort of know what it's going to taste like, where the source of it is, which is from the company that owns the trademark. Whereas if anyone were allowed to create a soft drink with the name Coca-Cola on it, it would be difficult for consumers to know what they're really getting. The same really applies in music. So if you go out and you purchase an album that says Madonna on it, you know which artist it's coming from and kind of what it's going to sound like. Whereas if any artist were allowed to release an album under the name Madonna, it would be very confusing for fans. So that's the intention of the trademark law, and that's why the protection lasts for as long as you keep using it. You can also lose it in certain situations if you allow the name to become what they call generic. So you want to be careful not to let that happen. It's probably not as common in music, but it could happen. So it's just something to keep in mind. So it's kind of, I always explain trademarks to people as being sort of a double-ended protection. So once you've registered your trademark in your name, as an artist, for example, it gives you a better ability to stop other artists from using the same or a similar name. The standard that they use is confusingly similar. So it doesn't necessarily have to be exactly the same, but if it's something that's similar enough that consumers could be confused and think that, it's coming from the same place, then it can be infringing on your trademark. So once you've registered it, you can then go out and try to stop other people from using the same or a similar name. The flip side of that is it also helps to provide some assurance to you once you've obtained the registration that another artist is not going to register it first and then come to you and try to force you to stop using the name. There are some exceptions. I don't want to go too far into the weeds, but there are some cases where, if two artists or two bands have been using similar names for the same amount of time, doesn't necessarily guarantee that if you register yours first, you can stop them. But in general, that's the protection that you will get. I mean, sometimes it gets very complicated and they end up actually splitting up the protection based on geography. So if there's a band, in New York with a name and there's a band in California with a similar name, and they've both been using it in their respective regions for the same amount of time, sometimes the protection is split up by geographic region. But in general, the trademark protection will help you to stop other people from using the name. And what I've been seeing, with all the new technology that we have, this creates issues sometimes. So I've had, clients where, for example, on Spotify, they have artist pages on Spotify. And sometimes if two artists have the same name, Spotify gets confused and one artist's music ends up showing up on the other artist's Spotify page. And so that's obviously a big problem. And once you have the trademark registered, it makes it easier to reach out to Spotify and these other platforms and say, hey, this is my name, I own it. Please sort out, make sure the music is on the correct page. So also common issue with trademarks within the music industry, and this is not a technology issue, is bootleg merchandise. So this is a common problem, especially for very popular artists, where people are selling T-shirts with the artist name on the T-shirt, and it's not licensed. And that's problematic, for several reasons. First of all, the artist is not getting paid for the use of their name on the bootleg, unlicensed merchandise. And secondly, there can be quality issues. So if people are selling very cheap quality shirts with the artist's name on it, that reflects poorly on the artist because consumers assume that it's licensed and it's coming from, if it's a t-shirt that says Drake on it, they assume Drake is the one that's selling it, and that may not necessarily be the case. So once the artist has registered the trademark in their name, it makes it much easier to crack down on bootleg merchandise being sold. And it can actually, in some situations with trademark infringement, become not just a civil trademark infringement issue, but some situations it's even criminal. If people are importing goods, that are using a trademark and they're not licensed, that can become a criminal offense. And again, the sort of intention there is to protect consumers. The government wants to make sure that if consumers are buying something with a brand name, which artists are a brand, and I think now more than ever, artists are being taught that they need to really create a brand for themselves, and that's what the trademark can help you to do.
So, when we are talking about trademarking names, you're talking about if there's an artist, uh, their name. You're talking about if it's a band, the band's name and logo. Any other things that would make sense to be trademarked?
Sometimes you can trademark packaging. So if you have a very unique style of packaging that no one else is using, and that when people see that packaging, they know where it's coming from. Probably not too common in music, but it's possible. And also catchphrases. So if you have a slogan, for example, Nike, just do it, that can be trademarked if it's used to identify the brand that it's coming from. So some artists have catchphrases, and they may want to trademark those if they're using them to identify, their products and services.
Okay.
Another thing to understand about trademarks, and again, this is different from copyrights, because with copyrights, once you register the copyright in your song, the song belongs to you, period. With trademarks, the protection is broken down based upon the type of products and services. So if someone has, the name registered in connection with restaurants, for example, that's not necessarily going to mean that someone else can't register the name for music or clothing. So it's important for artists to understand that. And many artists, would want to register for recorded music, which is one category. Live music is a separate category. And then merchandise is a separate category. So those are the three that are most common within the music industry. And ideally, to get the broadest protection, you would, as an artist, want to register for all three types of products. And if you're doing more than that, you would want to expand into whatever else you're doing as an artist as well.
So those 3 categories, I'm curious about live music versus recorded music?
Yeah, so the trademark office, they have a million different categories of products and services. And for whatever reason, they feel recordings are a separate type of a product than live music. So when you are applying for the trademark protection, you have to prove to the trademark office that you're actually using the name to sell those, whatever the specified products and services are. So for recorded music, nowadays, because everything is online, it makes it much easier. If you have, 3 or more releases that are out for sale on Amazon or iTunes. That's usually enough. For live music, you have to show ticket sales either online, so if you're selling tickets through Eventbrite or Ticketmaster or anywhere else under the name, or you can show that you have performed in more than one state. Because part of the requirement for the trademark protection, which is federal, is that you have to be using the name to sell the products and services in more than one state. So with the internet, that's made it much easier because if it's online, they consider that to be available to people in all 50 states. And, you can show that you're selling the product online, and that's usually enough. Used to be before the internet, you would have to show, that you actually have your clothing in stores in multiple states or that your CDs are being sold in multiple states. But if it's online, that makes it much easier.
So if it's a situation like, for instance, I am a songwriter and I do my own recordings, but I do not do live performances. So does that mean I'm less protected in some way because somebody else can go out there and do live performances with my name if it's trademarked, or no?
In theory, yes. Although, even though recorded music and live music are two separate categories, they're still related. So you would still have an argument that if you have the trademark for recorded music, someone else should not be allowed to have it for live music because even though it's a separate category, it's very much related. And so it could still create that confusion with consumers because again the standard is confusingly similar to consumers. So if you have a CD out under your name and someone else is going on tour under your name, I think you would have a strong argument that consumers might assume that the artist who is on tour is you.
Got it. Makes perfect sense. Thank you.
Just another thing to touch on is you might see that symbol, which is a circle with an R inside of it. When you see that next to a name or a logo, what that means is that they have registered the trademark and they own the trademark in that name. You cannot legally use that symbol unless you've registered the trademark. So that's another way it's different from copyright, where you can use the circle with the C in it, regardless of whether you've registered the copyright or not. With trademarks, you cannot legally use that symbol. You might see sometimes a different symbol, which is a small little TM, which some people will put next to their name. The TM symbol means that they are claiming ownership in that name, but they have not registered the copyright. So the circle R means it's registered. The little TM symbol means it's not registered.
Okay, because I actually did wonder about that. I'm like, people could just throw up an R with a circle and,
Yep,
but and they can, but they could get in trouble for that.
yep.
What about costs? So back to the process of registering a trademark. Is that it depends on what state you're in? Is it one fee because it's federal?
Yes, so it's a federal registration. It's done through the US Patent and Trademark Office. And once you obtain the registration for them, it covers you in all 50 states. Again, there are some situations that can come up where somebody in another state might challenge it, but assuming no one has challenged it, the registration will cover you in all states. It is a little bit expensive. It's more expensive, certainly, than copyright registration. And it also can depend on how many different ones of those categories of goods and services, because the registration fee is based upon each category and it's currently $250 per category. So if you're an artist and you wanted to do recorded music, live music, and merchandise, that would be three categories. So your total registration would be $750.
Wow. So I mean, unless you have unlimited funds, you really need to think about what you are trademarking. And then I'm assuming that let's pretend I want to trademark my name and let's pretend I want to trademark a symbol and let's for good measure throw in something else, anything. Does that mean it's 3 different ones times
Exactly.
the different categories?
Yes.
Oh, good lord.
Yes. So it can start to get very expensive, and it's kind of a balancing act. On one hand, you want to register as broad as possible, as many categories as possible, but you don't want your budget to get out of control. So it's always just a matter of what is the budget and what is the priority as far as what you really want to protect. And those filing fees, of course, they don't include the legal fees, which for trademarks, I do strongly recommend that people have a lawyer do the registration for them just because it gets pretty technical. And if they reject your application just on a small technicality, which happens a lot when people try to do it themselves, then you lose all those filing fees that you paid. So if you're paying $750 to do all three categories and you check off the wrong box or you use the wrong word, you're going to lose the $750. So it is something where it is strongly recommended that you have a lawyer help you out with it.
And in this case, is that a lawyer in your state or does it not matter?
For trademarks, it doesn't really matter because it's a federal registration. So, any lawyer who's familiar with trademarks should be able to help you out.
You said that if the trademark goes unused, which just means you don't re-register it, right?
Yes.
That you lose it? So is that an annual thing?
No, thankfully, no. It's after the fifth year and then after the 10th year. And then I think you're good at it, maybe every 10 years, but no sooner than that. So, and when you renew it after the fifth year and after the 10th year, you have to submit proof that you're still using it. And so that's how they know. And if you don't do that, you'll lose it.
Well, there you go. One more thing to add to that list of things to do. Now, in terms of what you're trademarking, is there research that you should do before you even go to a lawyer to make sure that it's available, or is that something that you don't find out until you go to register?
Yeah, you should definitely do a search. And you can do a preliminary search on the US Patent and Trademark Office website and kind of see, if anyone has anything that's the same or similar, which categories they've registered it in. You can also pay, there are services you can pay for to run a more comprehensive search for you. And then it's also not a bad idea to do a Google search and social media search just to get an idea. And it's always better, ideally, to do this early on as an artist, because if you find out someone already has registered the same or similar name, it's easier to change it at the beginning than, once you have put in a bunch of money toward branding and you've established your social media accounts and everything else. And then all of a sudden you find out you have to change your name. So it's something that you really, ideally, as an artist, you should do sooner rather than later. But if you've been around for a while and you haven't done it, it still is very much a good idea to do it.
I wonder how many people are going to quickly scramble and try to get that done. But at least it's good to know that, again, even if you have been around for a little while and you haven't done it, talking about myself here, that there is still hope that it can be done.
Definitely. Yeah, definitely. It's never too late. It's just the risk, is that the longer you wait, someone else may do it first.
Any other big tips around trademarking?
I guess just the last note, which I always find interesting, deals with the fashion industry, which is different from music, but very much related, especially nowadays. When it comes to fashion, trademarks become really, really, really important because a lot of fashion designers are not able to copyright their actual designs. So if they design a dress, it's for the most part not protected by copyright. So the logo is really what distinguishes the designer version of the dress from the knockoff version, which these stores that sell knockoff versions of designer clothes, it's legal to do that because, again, most of the time the designs are not protected. So the logo and the trademark in that logo becomes very, very valuable because that is really what distinguishes the designer version from the other versions. Same thing that you'll see with handbags or shoes. So trademarks can really, really be valuable and important to you if you're an artist, because a lot of days, a lot of artists now are moving over into fashion and exploring other opportunities and other industries related to music. So it's just something to keep in mind if you are selling any type of merchandise or if you're designing clothes. This is why people will pay hundreds or thousands of dollars for clothing with a certain logo on it. The value that is coming into that clothing is really from the logo, which is the trademark. So it kind of, I always like that example because it really shows the value that a trademark can have.
Wow, okay. No, that's a great point because 'cause you're right. I mean, obviously, a lot of people in the music industry are going into fashion, and it makes sense. But, of course, it brings up a question. What about album covers or single cover arts? Is that something that you would trademark? I would think that'd get really expensive.
Yeah, for the most part, album artwork is copyrighted. So if it's a photo, or if it's, a painting, a drawing, those things would be protected by copyright. If it's a logo, if you have your logo on the album cover, then it could be a trademark. But usually the artwork will be a copyright. But that also raises a good question because this is a question I get a lot as well. Sometimes people think that if they trademark the logo, for example, they have to trademark it every time they use it. And that's not the case. Once you have trademarked it for recorded music, say you've trademarked your name for recorded music, you're protected now for the whole category of recorded music. So if you release 100 albums under that name, each time you use that name, it's protected already by the trademark that you registered. So it's again different from copyright, where each album you have to submit the copyright registration for the new music. With the trademark, once you have it done, it'll protect you every time you use it.
Okay. Well, that's good news, and again, raises another question. So, for the cover art, when you mentioned that that's covered by copyright, does that mean that every cover art that you have done, whether it's for a single or an album, you actually have to copyright those separately? Or is it that if you have a distributor and once you submit that to them and it gets out there in the world and that song is attached to that cover art, that it's automatically copyrighted? Am I making sense?
Yes, you are making sense. The safest thing to do would be to register the copyright in the artwork, and also to make sure that you have a license or a work for hire agreement from whoever the photographer is, or if it's a graphic design cover, whoever the designer was. Because otherwise, what happens is the photographer owns the copyright or the designer owns the copyright. So you want to make sure that you have both an agreement from them stating that you own the copyright, or sometimes more well known photographers won't give you ownership, but they'll give you a license. Either way, you want to make sure you have the paperwork for it. And then to register, you would want to register the copyright in it as well.
So it gets even more expensive then because you're not just copywriting your music, now you're copywriting the art associated with the music.
Right. Yep.
Wow. Wow. Maybe that's a whole other topic for us to talk about because I don't even know if it works exactly the same way as when you do it for the music or if it's something you can do a group copyright or something. I don't even know.
Sure. Yeah, that would be a great next topic, album artwork.
Well, we'll never run out of things to talk about. That's for sure.
Yeah,
So, all right. I'm sorry. Back to trademarks.
no problem.
Anything else with trademarks that you want to share?
I think that we really covered, the main thing. Again, if you're an artist or a producer, main thing to understand is that the trademark protects your name. The copyright protects your music, but the trademark is what protects your name. So it's something to think about sooner rather than later if you can. If you haven't, if you're established and you haven't done it yet, it's never too late. But if you are just starting out, it's a good time to think about it so that if for some reason you need to change it, to avoid infringing someone else's trademark. It's easier to do it, at the beginning. You don't want to spend a ton of money on branding and establishing a presence and then find out that you have to change the name because someone already has registered it. So, just something to keep in mind. But I think other than that, we really kind of covered, all the fundamental stuff when it comes to trademarks.
Thank you so much, Cassandra, for joining me again and telling everybody, including myself, all these wonderful things that we need to know about the music industry and how to protect ourselves and how the consumers are protected. This has been amazing. And I want you to now tell us how we can get in touch with you and you'll probably be flooded with people that want you to register their trademarks.
Sure. Yeah. So you can go to my website, which is cspanglermusiclaw.com. And from there, you'll be able to find email, phone number, social media. You can also look for me on Instagram. It's cspanESQ. Twitter is cspanmusiclaw. And Facebook is facebook.com/musicattorney. So, but the easiest way is the website because everything is there. And again, that is cspanglermusiclaw.com. Thanks again, Janae, as always. It's always a fun time.
Thanks for listening to my conversation with music attorney Cassandra Spangler. Don't forget to check out all the links below, subscribe to my channel, turn on notifications, and like and comment if you got something out of this talk. Also remember, create, protect, release, and repeat.